people of the Eora Nation, and I want to pay my respects to their elders past and present, and extend my respects to any First Nations people joining us today as well. The structure of today's session, so I'll provide some opening impressions and remarks on the bill, and just to set the tone a bit, and then we'll move to a Q&A style panel session, which I'll facilitate with Darren and Joel. I'm sure many of you already know Darren and Joel, but just by way of a brief introduction, Darren's a senior lecturer at La Trobe University and is probably about as expert as you can be on the ins and outs of NDIS law. And Joel is a legal practitioner and program manager at VLA, and he manages their NDIS program. So I'll ask questions of Joel and Darren for the first half hour to get their overall impressions of the changes, and then we'll open up the floor for questions in the remaining half hour, and Mary will give me a hand in facilitating that. I think that I hope the PX article has been put in the chat, so I encourage you to have a look at that perhaps after this session. So, the government has released its long-awaited package of reforms. There's a lot of material to get through. The package includes the amendment bill, 2 new sets of NDIS rules, 2 amended NDIS rules, 3 updated NDIS rules, and then explanatory materials for all of those documents. So all up, we're talking about 16 documents that are open for consultation. And consultation closes in 17 days on the 7th of October. So there's a lot to get through, and we hope that we'll be able to simplify some of this for you. But I do want to set the tone here that this is not the doom and gloom that the first leaked draft was in March. There are no changes to independent assessments, no changes to reasonable and necessary supports. So there's nothing close to that level of overhaul of the scheme. It's not a fundamental redesign of the NDIS, which perhaps was threatened at one point. What we do have, though, are a series of pretty good changes, which should streamline much of the NDIS, and a series of changes which could do with improvements and close examination from advocates and participants. So with that kind of setting in mind, I want to throw to you, Joel, first. What's your overall impression of the package of changes, and what do you think are the key issues that advocates and participants should be looking closely at? Joel, I think you're on mute.
Sorry.
Oh no, you've gone back on mute.
Okay, now you can hear me. Whew, sorry. Thanks, Chadwick. Look, I first of all second what you said in relation to the fact that this is not a disaster. It seems to me, a package which does a number of things which the Tune Review suggested should be done to improve the scheme, and even in relation to the participant service guarantee in particular, and we'll come to this in a little more detail later on. In some ways, there are some thoughtful additional items, additional measures taken that were not suggested by the Tune Review, which are positives. So I think there are some positives to take away. I think that there are across the board a lot of measures which put a lot of discretion in the hands of the agency and the CEO, and it tends as an overall package to err on the side of giving more power to the agency rather than less, I think. And so I think there is value in advocates looking at some of these changes and working out whether there are ways in which that power on the part of the agency, on the part of the CEO, should be cabined or contained to some degree or shaped in some way. And we'll talk more about the way in which that might be done over the course of the next half hour. But for me, a really big area of focus is going to be on the proposed changes to the variation and reassessment of NDIS plans. That's an area where I think a bit more guidance would be useful.
Thanks, Joel. And Darren, same question to you. What do you think are the key issues that we should be talking about?
Yeah, I mean, I'd echo the positivity, and the positivity comes from the work many people on this call did, and it's important that people feel that work pays off, and the truce has held, the truce the minister committed to. I think I would just focus on NDIS law continues to look a certain way. So the act, the legislation gives a power. It then says, we'll spell this out and put some structure on it in the rules. The rules enter and say, the CEO will think of these things. And 3 months later, after the legislation has passed, the agency has to sit down with us all and kind of nut through all of the, not through an actual detailed policy. And I think one of the things that we want to get in terms of developing the NDIS is using Parliament to have the exchanges earlier, to make clearer in what direction the powers are flowing. Also, I just flagged that whenever they rely on rules, they are actually gaining a vote. So if they don't put it in the legislation and it's being put in a rule, the rules aren't voted up. They can only be voted down, which means they require one less vote on disallowance. So those big governance issues, how we do NDIS, I think we should still keep those prominent. I think there's lots of good things here, and one of the things I don't want to do today, I'll talk a little bit about the access reforms around psychosocial, which is something I'd like to see more clearly defined. But I think it's really important to focus on other opportunities apart from criticism. So there's a bit in here on market intervention, which is thin markets and measures the CEO can take. Now, as lawyers, obviously, we might focus on courts and sort of potential appeals and disputes like that. But that market intervention part, on its own is an area where if you're having trouble in rural and regional Australia or with particular groups in the NDIS, you want to put in a strong submission on that, a positive, strong submission. So let's run a very balanced engagement with the draft, I think.
Thanks, Darren. Let's stick with you. I mean, you're one of the key things you talk about for a long time, even outside of these changes, is this rulemaking, the way in which the NDIS is structured around the rulemaking powers and the expansion of rules. I think what we're seeing with this particular package of reforms is a continued reliance on rules, and there's the 2 new rules, and emphasising again the importance of the rules in getting access to the scheme and around plan management. Can I ask you to talk a bit more about that? So why is the expansion of rulemaking power such a big issue, and what are the proposed changes in the rules that we're seeing?
So essentially, when we look at using NDIS rules, if we take the access reform, so the access reform says something like the NDIS rules can specify requirements which must be met. Up to now, it's been criteria, which are broader and sort of flexible. This draft, this revision to the Act would allow them to make all or nothing requirements. And now, again, there's nothing wrong with that. It just gives them more flexibility. And then they say the requirements will be spelled out in the NDIS rules. When we look at the becoming a participant rule, we have really a new access pathway to the NDIS for psychosocial. And the natural question you ask as a lawyer is, why isn't that in the Act, the primary legislation? And as I said, the main thing that comes from that, as we're moving into election season, senators have a special responsibility towards the NDIS. Like, there should be no one standing for the Senate in the next while that doesn't have an understanding and at least a position on the NDIS, because when we're dealing with these rules, when they introduce the rules, you have 15 days to get a senator to object, and then 15 sitting days. And then after that, you have a vote in 15 sitting days later on whether the rules should be allowed to go through or whether they should be disallowed. So there is a governance question here about what goes into the legislation and what doesn't. And I think in terms of the role the crossbench played in the debates around independent assessments, again, it's worth underlining that primary legislation, given the importance of the NDIS to Australia as a whole, which everyone has been shouting about in the last 3 months, you know, these things should be dealt with through primary legislation, through an up and down vote in Parliament. And when we look across all of the variation powers, reassessment powers, they take a structure of the CEO can vary and his power will be limited by rule. The CEO can reassess and his power will be limited by rule. And again, it's not healthy that the NDIS can be 30 sitting days from dramatic change. That's not the tone we want. We all want to have an organized process whenever changes come down. So I think we can sort of it's just a global issue. It's not something that's really confronting criticism. It's just something that can be underlined, I think. I mean, I'd like to get into the access, I think, at some stage, but I'll bounce it back to you, Chadwick.
No, please do, Darren. I mean, that's a good sort of umbrella point for all advocates to be considering in this reform package is really looking at the continued structure of the NDIS Act and the way in which we can push for change there. But let's get into the detail about some of these rules, and you talk about the access rules or becoming participant rules. Can you talk a bit more about what exactly is proposed there, as well as if there are other rules that advocates need to be looking at?
Yeah, so I mean, I might just take on the access, and I think Joe will get to variation. With the new access rule, we have a new pathway or way of qualifying for the scheme for psychosocial disabilities. Now, everyone will be drawn, I think, when you open up the new becoming a participant rule, everyone will be drawn to the fact that there has been a shift in the language. So there is the shift towards saying that away from no known, available, appropriate treatment to remedy the impairment towards reasonably available. Okay, but I think that is a part of the rules, that new psychosocial access pathway, where we could really do with more guidance. So it says things like a person will be a person who has been in the health system effectively and has been undertaking treatments to manage their condition. If after a period of time, assessed on a case-by-case basis, they have shown no substantial improvement, they may go to the NDIS. Now, what's missing is a definition of what managing is. We don't have that in the Act up to now. What does it mean to manage a condition? What is the point at which the person exits? What is a substantial improvement? And the thing that struck me reading it was they didn't have a provision saying if after a period of time there is no treatment which is likely to remedy the condition, the person goes to the NDIS. Instead, there is no management option and the person hasn't experienced a substantial improvement. And there's an ambiguity there about you know, the exit point. And I'm only going to call it an ambiguity at the moment because this is at the stage of an exposure draft. We just want to engage, you know, and get more clarity around that. So again, I think, you know, it isn't the psychosocial reform was expected because it was fully flagged in the Tune review. But as a lawyer, I would say we need a bit more stepping through what managing a condition means, what the period of time, how that's going to be calculated, and what a substantial improvement is, because a person can present in crisis, improve a bit, but still be below substantially reduced. So more explanation needed there. The last thing I'd say as well is some of you may have noticed in relation to other disabilities apart from psychosocial, there is a new emphasis on the functional improvements that can result from medical treatments. So even for non-psychosocial impairments, there's now a new clause in the participant rules that says that it basically makes us ask, will the medical treatment maybe not remedy the impairment, but will it bring the person over substantially reduced capacity? Will it lead to a functional improvement? Now, we can get into the technicalities, and I can sort of say, really, that's more of a clarification rather than a huge change. But what it should focus us on is disabilities where there is a treatment option that doesn't aim at curing the condition, but at managing the function and improving the function. So with things like chronic illnesses, I think this provision underlines that if there is a functional intervention that might be in the health system or could be in the health system, this clause gives stronger ground to the agency to name that in the eligibility process and say, hey, you should be doing graded exercise therapy if you have a chronic condition, or you should be doing some functional intervention over there, not in the NDIS. So again, those would be the two things I'd flag on access.
Thanks, Darren. It sounds like there's a lot to pull apart for advocates there, and especially with their more practical on-the-ground experience about psychosocial disability and those sorts of thresholds. Joel, I want to move on to you to talk about plan variations and reassessments and reviews. I mean, that is in some ways it's a pretty small shift, in the sense that it is just clarifying some of the language between, plan reviews, unscheduled plan reviews, internal reviews, external reviews. So there's some of that, but there is also a bit more meat to the changes around Section 47A and Section 48. Can you talk us through these changes and any concerns about these changes?
Yeah, absolutely. So some of you might recall that in the Tune review, one of the issues addressed was the issue of there only being one power by which, outside of the merits review process, outside the cycle of that process of merits review, there's only one power that can be exercised to change a plan. And so this is the Section 48 power, and the effect of a variation, a change rather, under Section 48 is that the plan would be replaced. And that, as the Tune review recognised, had adverse consequences from the practical. Things like bookings had to be remade when a new plan was made, through to it having implications for the jurisdiction of the tribunal on merits review. So for a whole lot of reasons, the Tune review recognised that there was a need for a variation power, and so it proposed what it called a plan amendment power, and in the draft exposure draft legislation, it's described as a variation power, and this is set out in the new Section 47A. So the exposure draft inserts this new variation power in Section 47A, and the upshot of a variation is that it doesn't replace the plan. The plan continues with the changes built in, whereas Section 48, which has been redrafted and is proposed to take a new form, that will now be called the reassessment power, and that's a power which, if exercised, does replace the plan. So you get a brand new plan if the reassessment power is exercised. So, I mean, the first thing to note is that this addresses a concern that lots of people with disability and advocates had, that this very blunt tool of plan review had adverse consequences for some people who had that sort of review undertaken. So it's a good thing in that respect that this variation power is inserted. There are a few things that I think we probably do want to push the government on. And the first of those is that the Tune review laid out a specific set of circumstances where it said it would be appropriate to have this kind of new power used, and laid those out in the report, and those particular circumstances are not the only circumstances in which this new variation power can be exercised. It's unconfined, the CEO's power to exercise this variation authority. And so I think there is a question as to whether, as a sector, we should be pushing for the legislation to reflect that limited set of circumstances that the Tune Review said the variation power should be capable of being exercised in. The counter argument would be, we can't predict all of the circumstances in which it might be appropriate to have a variation rather than a reassessment of a plan, and we should leave substantial scope to the agency and the CEO to have to deal with the wide range of situations that might occur. But then I think we would expect to see reflected in the proposed rules, which govern to some degree how this new variation power is to be exercised, some express articulation of those circumstances that the Tune Review said were the right circumstances for the exercise of the variation power. And that list is not in the rules. There's a list of much more general considerations in the rules, and so it really doesn't confine that discretion that the agency has to decide to vary or not to vary. So I think it's worth looking at that, looking at the rules at 10 and 11 in the proposed plan administration rules, and giving government a little bit of a nudge on the question of why this power needs to be so unconfined. That's one issue. The other issue is that the variation power is proposed to be exercisable at the CEO's own motion or at the request of a participant, but the new section 48, the reassessment power, provides for reassessment only on the CEO's own initiative. So a participant can't say, well, mine is not a good case for variation, mine is a case for reassessment and a new plan. And I don't think there's any reason not to allow a participant to request that. I mean, the agency is not bound to do what the participant asks. And so there doesn't seem to be a cost to allowing people at least to ask for that process to be undertaken for the reassessment rather than the variation. So those are probably two key areas for focus. And you know, I should say there is it is good to see that there is an amendment to the merits review provision, so that if a plan is varied, the tribunal, if it already is hearing an appeal in relation to a plan, will be deemed to have jurisdiction over the plan as varied. So it'll give the tribunal full scope to look at the plan in full, even as varied. But as I read the proposed legislation, it doesn't do the same for a Section 48 review, for a reassessment where a plan is replaced. And that has created some problems for the tribunal in the past. And so I think that perhaps also is an area worth looking at. Those 3 points, I think, were the three that I think I would want to raise. One is, you know, should it be unconfined, the variation power? Two is, should people be able to ask for reassessment? And 3 is the set of changes in relation to merits review at the tribunal, is it sufficiently protective of people's rights to seek review?
Thanks, Joe. And I'll just throw a question to you, which has come up in the chat, which relates to what you've just talked about. Kathy has asked, how is the plan variation different to a change of circumstance review? Now, my understanding seems to be that this is essentially just legislating what they were kind of trying to do around the edges anyway. Is that right?
Yes, that's right. It means that in a technical sense, there's a statutory basis for making a variation which doesn't replace the plan, and provides some process around that. and some criteria, I would say not sufficiently clear criteria, but some criteria about when that's the right step to take, rather than a review under what will be called the reassessment power, which would replace a plan. Does that make sense?
Thanks, Joel. Look, before we open it up to the floor, I just want to get some comments from both of you about what else might be missing from the reform package. I mean, within the circumstances of, obviously this isn't a fundamental redesign of the scheme, but what should advocates be considering pushing for that isn't in the package? Darren, perhaps we'll start with you.
Yeah, I think me and Joel might overlap, but I mean, I don't think it's gotten out to the to politicians sufficiently about what's happening in the tribunal around appeals and the QD-KH rule, and the difficulties people are facing taking appeals at the moment. Like, I do think we need to, Tune is all about getting us on the same page about the business processes of the agency. So it's all about saying, if there is a problem, we deal with it holistically and we deal with it once. And for those advocates working in the tribunal, I know that they will be very frustrated a bit at QD-KH and the dynamics around the need to put the right thing on the form, to name the right supports. But I might pitch that over to Joel as well. But just as well, in terms of positivity, I think I mentioned the market intervention part of plan administration, and I think it's really important that we underline the positive use of its powers of assistance. So the agency has the ability to conduct market intervention to grow the market in particular areas. I would like, for instance, Indigenous Australians and their connection to country to be a factor in the use of those market intervention powers. I would like urgency and service breakdown named as relevant factors in the decision to apply market intervention. I think we need to talk. We've had enough of the agency being on the back foot. I think we also want to talk about the agency getting on the front foot and dealing with cohorts who have stalled out, difficult areas of the scheme. And there's enough hooks here in the legislative package that will allow advocates to put forward that positive agenda that your organisation has waiting, that got frustrated in defensive battles over independent assessments. So I just really would underline, run with, Tune is access to justice within the scheme. Run that access to justice, show the people who are stalled out in their applications how the agency can help, show the people who can't access services. Don't forget that positive agenda.
Thanks, Darren and Joel. And Joel, if you could just give a quick summary of what QD-KH is and what that issue is as well.
Sure. So, look, QD-KH is a decision of the tribunal which said that the tribunal's jurisdiction in a supports matter is limited to reviewing the decision made by the reviewer at the agency, and the implication drawn from that was that if there were new supports raised at the tribunal, that they couldn't be considered. Now, I mean, just editorialising, my view is that runs totally contrary to our common understanding of how merits review works in Australian law. It's meant to be a practical means of access to a remedy. And this is elevating technicality over practicality. And I don't think there's anything in the legislation which warrants that reading. It also, of course, doesn't reflect the reality of the lives of many people with disability who have supports needs which will change over time and can readily be seen to change in many cases between internal review and tribunal review. So that's the basic principle, though, that the tribunal has articulated in some cases. There is a contrary line of authority which says the tribunal absolutely can consider new supports. And this is being litigated by my colleagues at Legal Aid New South Wales. They've got a matter going before the full court of the Federal Court in November. And there is a question about whether this limitation will stand. But I think, particularly given that this proposed legislation will change merits review processes in various ways, I think this is an opportunity for us to say to the government, look, for the avoidance of doubt, the legislation should be amended to reflect the common understanding that we all had going into this, which is that the tribunal would have full scope to look at whatever supports people sought when they got to the tribunal. And so we'll be putting that, I think, in our submission.
Thanks, Joel. Great. That just wrapping up the panel part of the session. Perhaps if I can summarise some of what we've discussed. It sounds like really the overarching point about this review package is that it does give a lot more discretion to the agency and to the CEO in a number of respects, and that's an ongoing issue that we just have to address when we can. The way in which it plays out is that your concerns, Darren and Joel, primarily around the access rules on becoming a participant, as well as in relation to plan variations and the power, again, the power of the CEO to vary participant plans with essentially an unlimited kind of scope. And then we talked about what we're kind of missing, and really the idea is that the Tune Review, the basis of the Tune Review, is about access to justice for the scheme, and there are two ways in which there are missed opportunities that hasn't been done in terms of fixing QDKH and the jurisdictional question, and around market intervention, something positive that the agency can do to really reflect the underlying intentions of the Tune Review. Perhaps if we can we can throw it open to the floor now for questions. Mary, do you want to come back in and facilitate?
Yes, thanks, Chadwick. And I can see, let me just go to, so I can keep an eye on people who've got their hands up. So obviously, if you've got a question to ask, put your hand up so that we can see you. That'll help us manage it. I'm just trying to get back up to the top of the participant. I can see who's got their hand up, which it's not letting me do easily. Stacey Reese is the first person. You can turn your camera on if you want, Stacey, but just take your microphone off, whichever.
Thank you, and thanks for providing this opportunity for us. I just wanted to check, my reading of section 48 is the reassessment on CEO's own initiative. Once that process has been started, it must result in either a variation of the plan or a new plan being created. I'm just checking, is that correct? And does that mean that if, say, the CEO of their own initiative does begin the reassessment process, there's no opportunity for a person who may be happy with their plan to maintain it as it is?
So I think I haven't thought this issue through before now, but I'm going to shoot from the hip. I think that I think that it would be possible to exercise the reassessment or variation power and ultimately not make a change to the plan. Darren, would that be your view as well? That you could formally go through that process and not actually change the plan at the end of it, but still have discharged that statutory power?
Yeah, although I just think as a matter of pragmatics, I think they'll want to control the reassessment dates, you know? I mean, one of the fears I have about own initiative reassessment and variation is it can kind of be used to hotwire the participant service guarantee. If I'm really cynical, if you look at the way, if they have an unconfined power to reassess and vary, they can change and shift the timeline on your client, you know? And it would be hard to imagine, as a matter of practice, the CEO not making a change but leaving the reassessment date the same. Would you agree, Joel? Like, so I kind of think, yeah, they can not change the substance of the plan, but as a matter of practice and bureaucratic convenience, I don't think they will. But I would agree with the formal reading. But in practice, I think they'll want to bank the reassessment as a reassessment and put your plan reassessment date further off.
And also on that, are we aware of whether any notice will be given if a reassessment takes place? Or is that something that might be included in rules later? Or?
I mean, I would expect that there would have to be notice given. I mean, I would have thought, apart from anything else, that there's a procedural fairness obligation which the agency has. I can't off the top of my head recall whether the rules specifically address this, Darren. I'm not sure if you recall off the top of your head, but I would have thought that as a matter of procedural fairness, they would have to provide some notice. Any thoughts on that, Darren?
Yeah, no, I think there would be an obligation. Yeah. I think part of the issue is we're dealing with a exposure draft that sort of inserts into the primary legislation. So, I mean, I think a reassessment of a plan attracts obligations to engage with the person. Yeah. Yes.
Yeah. Thanks, Stacey. Hayley Stone has her hand up to ask a question, but there's also a question asked by Jane Britt from Blind Citizens in the chat about, can someone briefly explain the difference in really basic language between reassessment and variation power? So if somebody wants to have a go at that first, and then Hayley, you can ask a question.
I can have a go. I mean, the basic distinction is that variation changes the plan without creating a new plan, whereas reassessment changes the plan and creates and makes it a new plan. So and the way in which the Tune review talked about this proposed variation power is that it should be the more minor stuff which is done by variation. So it's everything from sort of typographical errors to, you know, we need to implement a change that was agreed during the course of a tribunal appeal, you know, all sorts of little odds and ends that are fiddling around the margins, but are not a fundamental shift in the sort of package of supports that somebody gets. Whereas a reassessment, you're really looking at changing up something in a more substantial way, and so it's a new plan. It's not just a variation of the old one. Does that help to clarify?
I might also just add to that part of the issue is also the discretion of the CEO. So, I mean, while we can kind of talk about how the intention of a variation is meant to be fairly minor and a reassessment is meant to be a bigger foundational issue, it's ultimately the CEO or the delegate who's going to decide, is this minor enough for a variation or big enough for a reassessment? And the criteria, if I remember correctly, is the same for both. They have to consider the same sorts of things and then just put it in the variation basket or the reassessment basket. So I think that is something for advocates to make submissions about in terms of putting some parameters around how this power is exercised.
Yep. I mean, I think that's right, and I think it is something on which advocacy is appropriate. I would say that I think there's an interesting question about whether the fact that you have a variation power and a reassessment power does limit the scope of the CEO and delegates at the agency to run away with the variation power and just do whatever they want via that process. Because, you know, implicitly, if you're making a big change, clearly the scheme is intending that big change be made by way of reassessment. So it might, by implication, limit what you can do by way of variation.
Thanks. There's a couple of people are commenting about the plan variation seems to be like the light touch review.
Exactly. And Tune Review talked about the light touch review, and in the course of that discussion came to the recommendation, which finds its form now in section 47A. Sorry to cut across you, Mary, and I think Darren might have been about to jump in as well.
Yeah, I mean, so Tune at 8.33 had a list of situations when variation is appropriate, so A to I. And what I expected when I opened the legislation, I expected a situational power. So in these situations, variation is welcome. and we didn't get that. So some of the question is actually being generated by the openness of the legislation and the rules, the discretion. But if you go to tune 8.33 A to I, he identified what he described as the limited circumstances where the agency can come in and smart bomb an aspect of the plan. They can detach it and say, we'll just change the reassessment date, we'll change the plan management, light touch, we're not destroying or disrupting the rest of the plan, and it doesn't trigger a reassessment. That's the intention of the variation.
Thanks, Darren. Hayley, your turn to ask a question. Thanks.
Thank you, and thank you to Chadwick and Darren and Joel. This has been really, really insightful. I guess for me, my primary concern is about the investment of power in the CEO and just the implications that that's going to have, given that it sounds as though the CEO is being granted more powers than previous. My question to the panel is, can you foresee any potential problems in terms of participants being able to take the administrative appeal channels, given this increased power that's being put into the CEO?
Well, I mean, yes, I could certainly come up with scenarios, I'm sure, in which, and particularly if there are rules made in future, which are, I mean, a lot of the rules as proposed, you know, have areas for, you know, concern, or there are questions about how they might be applied, but they're not flashing red lights. They're not, you know, they don't look like disasters. But one could certainly imagine a future where rules are made where, you know, really has the effect of constraining review rights. I mean, I'm not sure how much you can make of that as an advocacy point at this stage, because I don't know that there's anything in particular that you could kind of hang that argument off of at this stage. Darren and Chadwick, do you have any thoughts on that?
Well, for me, like with access, when I say we need more definition of what managing is, we need to know what substantial improvement is. When something is open, the agency can fill it with policy that the tribunal will attach great value to. It can be perceived, like one of the words that was used in the federal court that really worried me in WRMF, the supports, the question around sexual supports in the scheme, the federal court called reasonable and necessary an evaluative judgment, and that's judicial code for these are difficult decisions and people shouldn't second guess, and the agency should be given scope to make policies. And when I read the access criteria and the plan management rules, which are about measuring risk, I see drafting that is about setting it up as evaluative powers, open, free, that can be filled with agency policy. And in that sense, you'll always be able to access the tribunal, but there will be this argument that Parliament wanted the agency to have scope for judgment. So when I say we need to have more definition here, I am saying we need to have something we can appeal to in the tribunal.
So is that, so essentially increased policy and something tangible that we can cling to would increase our chances of being able to get successful appeals in the tribunal.
Yeah,
and having the CEO be able to wield control, which isn't focused on, isn't based on any policy which is underlying it, provides an ambiguity that could be problematic.
Like, I think the best example at the moment is the calculation of the time period for a person with psychosocial disability. Like, if you look at there's very little in the legislation. It says case by case. That's a judgment call. And what are you going to say in the tribunal necessarily? Like, you know, we need a bit of structure on that in terms of what's guiding the doctor's judgment about how long is enough? Is it data on the treatment the person is on? What is it, you know? So I just want to see that advanced So we can argue about it now, but also have struck a way of analysing and reasoning through things when we get to the tribunal. Because at the moment, all the explanation document says about the period of time is case by case, person by person, guided by the doctor.
Yep. No, thank you so much, all of you.
Thanks. The next two questions are from Nabil Mohammed and then Wendy Prowse. And can I ask you to introduce your which organisation you're from as you come in? Thanks.
Hello, this is Nabil Mohammed from Side by Side Advocacy. I want to ask a question in regards to, you mentioned in regards to permanency, right, and how that will be determined. Now, would that affect existing participants? Could the NDIS go back and say, well, we now consider your condition to be treatable by like healthcare, therefore NDIS isn't the best fit best fit for your condition? Could that happen? Because we know when you do an ACAT assessment that's your pathway off the scheme. Could this be another pathway off the scheme?
Sorry, I'm happy to take it. I mean, I would just make the comment that eligibility reviews are increasingly inbuilt into the agency's procedures. So they are always looking at whether the person meets the eligibility criteria. I don't know what others think in terms of. I don't necessarily think it's not like everyone has to retrospectively meet these criteria.
No, I think that's right. But yes, as you say, they are likely to sort of inform the way in which the agency goes about its business. As you say, in the course of regular assessments.
Yeah, I just add. I mean, the power to revoke or exit someone from the scheme is in Section 30, and the CEO can consider whether they meet the disability criteria. So I would assume that if the disability criteria changes, which under the rules they would. Well, I mean, I don't know if they're changing so much as there's a bit more substance to, what the criteria is. So I mean, I suppose I wouldn't rule out the possibility that someone could go through the reassessments for a psychosocial disability and come up with a different outcome. But I'd be surprised if there were a lot of people who fell in that criteria.
I would make the comment. See, I don't necessarily want to cause a stampede of concern around that. I think we're all having the same reaction. I just make the comment that the minister did point to certain cohorts in recent Senate testimony. The sense was that there were some cohorts who were automatically onboarded via the federal programs that they would see as, had they their time again, they would have run the rule a bit closer on eligibility for some of those people. So of course, revocation does happen. We've had at least 2 tribunal matters where revocation was appealed. I think it's important advocates are aware that revocation happens. But we need to evaluate these changes, focus on how they can be improved. They're there for a reason too. I didn't want to come online and pillory. I have no issue with someone being connected with solutions. And everyone in the sector worked very hard on Tune, psychosocial. There's been a lot of work done on it. We need to make sure that this definition gets the balance right in terms of putting people in the NDIS who meet the criteria, who are on a sort of severe pathway, but also we need to make sure that the oasis in the desert dynamic that Bruce Bonyadi talks about so well, that we also will have people on the edge of the NDIS, and we've got to work to get an assertion of responsibility from the states for those people as well. And of course here we're dealing with an amendment that is the federal side only. So it's all about balance for your organisation in terms of getting a read on what these criteria mean, making them as good as we can, and then also working on the edges of the scheme, which we know are a huge problem.
Thanks, Darren. Wendy Prowse has got the next question, and then Cherry Belosis, and then Bernadette Dwayne.
Thanks, Mary. Thanks, Darren, Joel and Chadwick. I would just be really interested in your thoughts around reducing red tape in this process? If we think about the reassessment, and Darren, as you sort of allayed, you know, the CEO can decide that they can wait things out, they can change things around, so that potentially we're sort of tying ourselves up in knots as we're trying to support people. Is there something where you can provide, and it doesn't necessarily have to be now, but just some guidance around how do we reduce the cost of the services that we're trying to provide by reducing the red tape of this process, and whether that comes back to timeframes, whether it comes back to sort of other thoughts and considerations, so that we can stop having people having to wait considerable amount of time to either be able to get their plans changed or amended, or going through the tribunal. It just seems, I feel like at the moment, most of my team just seem to be spending all of their time back and forth. Is there anything that we can put in place through the Act that can help reduce that?
So I'm not sure I have a great response to that, but I have a couple of thoughts. I mean, one is that, you know, look, the legislation of time limits as part of the participant service guarantee actually is a good way of, to some degree, getting the machinery of decision making moving. And so I think there are some positives there. And so holding the agency to account for adherence to the timeframes is one thing that you can do. I mean, I guess the other thing I would say is in relation to changes to plans, there is now no question that, well, when I say there is now no, assuming that something like the proposed legislation goes into effect, there will be no question that the agency has the tools it needs to make the appropriate changes to plans with the appropriate downstream implications in terms of tribunal jurisdiction and whether the plans were placed and a whole range of other things. So that they'll have all of the tools they need to make the right choice in light of the particular change requested. And so hopefully there is less wrangling over how you get the plan changed, and there are less adverse downstream implications from that. And it might be, in terms of what you can do, just over a matter of over time, becoming more and more conversant in these powers as they play out, and asking for the right type of change and pushing the agency to exercise the right one of those powers. But that's something we're going to have to work on as a sector, I think. Darren, did you have anything you'd add in relation to that?
Yeah, I mean, I just think we're the length of plans, you know, shifting off the annual treadmill. To me, that is going, outside of clients who are, not in a situation of stability. I still think a grown-up NDIS means longer plans. It means stability. It'll relieve pressure on the agency. And I hope that the dynamics advocates are experiencing will lessen a bit if we get more stable plans. Now, what we need to make sure is that the wheels of bureaucracy don't, we've got to get people focused on the actual important bit, which is the services and the improvement. And I would share the concern that, when I look at the variation power, one of the reasons I want to be super clear on when variation happens is I don't want the CEO doing it for administrative convenience. I don't want 3-month ad hoc extensions because the planner in that region is under pressure. Now, I'm not clear that's ruled out in the current draft. And I think we've all encountered very ad hoc processes by an agency in the context of a pandemic as well. I just think the message we need to give to people is, you have your plan, go use it, and support people to use their plans. And I think the whole sector is waiting for that moment. And my hope really lies in, yes, the timelines, but more than anything, the longer plans, I'm hoping, will reduce pressure.
It's Mary, and I'm just diving in because I suspect what's going to happen is in 2 minutes' time, the whole thing is just going to cut out and you'll all get kicked off. So what I'm going to do is, for those of you who've got your hands up and still have questions, we're clearly not going to have time to get sensible answers to all of them. I know Darren has to go because he's teaching in a minute. I think I'd ask those of you the questions, and there have been some others put in the chat, to email the questions and we will forward them on and get some answers. We're going to send around the transcript from today's forum. We will send around to everybody, so you will all be able to read what people said today. I'm going to talk to Darren and Joel and Chadwick, and we'll see if we can do another one of these in the remaining time. So in another week or 10 days, when those of you that are going to be writing in submissions and responses to the legislation, once you've started to frame that up, and you might have some more very specific questions, and I think if we can, if the speakers can find time to fit in another session, I think we will do that, I think, because it's really useful, but we're just not going to get the time today to give proper responses to your questions. So if you can email Dana, email us at ceo@dana.org.au with your questions, and we will get responses. It's been very valuable, and I can tell there's a desire for further discussion, and I think it'll help if organisations have started to frame up their responses and their submissions. I think then that might it might be of further assistance. So put your if you can continue to put your questions in the chat. I think that will probably stay live for a little bit, and I can already see people responding in the chat to say that an additional session would be very useful. There is Chadwick's part of is running a working group on this later on this week with some of the peaks, the other disability peaks, and I think we'll also in that forum get a chance to think about some of these things. So thank you very much to Darren and Joel and Chadwick for doing this today. And we'll, outside of this session, we'll find a date and a time for the next one where we continue the discussion. Okay. Thanks everyone.
Thank you.
Thanks everyone.
All right.
Thank
See
you.
you. Bye bye.